Our next speaker on ERISA this morning is Mike Maxwell. Mike boldly agreed to take on what one of the most challenging issues, subrogation issues, is that we have to deal with, which is once we've established that we've got an ERISA plan, what the heck do we do now? Particularly in light of the United States Supreme Court's decision in McCutcheon. Mike has had kind of an interesting legal career. You can read his bio, but I will just say he's got a lot of trial experience in both the criminal and civil arenas, and he's someone that I personally know has given a great deal of thought to the subject of ERISA. And today I think he's going to kind of provide us with the necessary background and framework for tackling this thorny issue. So, Mike.
Thank you. All right, everybody, good morning. Are my materials going to come up? I was having lunch with a friend of mine a few weeks ago, and he said to me, 20 years ago, we had to fight to get the money for our clients. Now we have to fight to get the money for our clients and then have another fight to keep it. And he's right. Everybody wants to take a piece of the personal injury recovery, whether it's the government through Labor and Industries, whether it's Medicare, whether it's Medicaid. And now you've got these ERISA plans that are trying to get to the front of the line. All right. So, my materials are called The Good, the Bad, and the Ugly, about the Supreme Court dealing with McCutcheon. Mike Nelson is here. These are materials, hi Mike, that I stole from him. He gets the credit for them. So the first decision that was the good one was the Knudsen decision, written by Justice Scalia, of all people. Talked about how ERISA or the statute that allows ERISA subrogation is an equitable statute, and therefore the only right to get money in subrogation is an equitable right. So what's the difference between a right in equity and a right in the law? In equity, let's just say that, for example, Maria has stolen my dog, and I want to get my dog back. That would be a right in equity. And if she no longer has the dog because the dog has escaped or the dog has died or something like that, then I cannot sue her in equity. I can't make her give me the dog back if she doesn't have it. If I want to sue her for the fair market value of my dog, that would be trying to get a judgment that I could apply to her assets. That's a judgment in law. It's not a judgment in equity. So equity is designed to produce specific performance. And in the Knudsen case, what happened was the money had been distributed to the injured party, the case had been settled, and the injured party no longer had the money. And so the Supreme Court said, the dog has escaped, and you can't have an action in equity. That's right. Appropriate equitable relief is not allowed. All right, so the second Supreme Court case that came about was the bad one. It was the Sereboff case. And what happened in Sereboff is, I'm going to go through it very quickly, but they went out and got an injunction enjoining the attorney, or the attorney agreed to not distribute the money. So now the money is in a specific and identifiable fund, and the United States Supreme Court said, well, that's the dog. And as long as the money is in a specific and identifiable fund, then the ERISA plan can attach it in equity. Again, it was all about equity. So in those days, the idea was that if you notified the Rawlings Company or one of these big, Boeing or something like that, they would go out and they would threaten to file a lawsuit in the United States District Court and ask for a temporary restraining order which would restrain the plaintiff's attorney from distributing the money that the plaintiff attorney got on the personal injury settlement. And then what happened is ERISA plans started writing into their plans the idea of a constructive trust. So that when Maria gets a job for $7 an hour working in the lumber department at Home Depot, they hand her a glossy, the employee handbook. And it's full of pictures of photogenic people, photogenic actors looking like happy Home Depot employees with orange aprons. And buried there on page 67 is your medical rights. And the medical rights talk about subrogation. And they talk about how if they pay benefits for injuries, for hospital care, or anything else, then they have the right to be repaid. They don't have to pay for your attorney's fees. The made whole doctrine does not apply. And the plan will establish a constructive trust, meaning that they can sue Maria or anybody else who has her money, including her personal injury attorney. So that's why they're using a contract, what the United States Supreme Court calls a contract. So you're asking about how can they do this? Would they call this a contract? The glossy handbook that they hand to the employee that they change anytime they want, according to the United States Supreme Court, is a contract. I guess that because Maria comes to work the next day, she's accepted the terms of the contract written by Home Depot. And in that contract, they say that they can establish an equitable trust, and no longer do they have to go to the effort of filing a lawsuit in the United States District Court and asking the District Court to issue a temporary restraining order to restrain the plaintiff attorney from distributing the funds. This is why if you have money in a personal injury settlement, and if you notify the plan that you have the money, and if you give the money to your client and say, to hell with those ERISA guys, I'm just going to give the money to you, to my client, this is why you can be sued. You can personally be sued. There's been quite a bit of litigation in the Ninth Circuit and at trial courts about whether the plaintiff's personal injury lawyer can actually be sued, and whether that plaintiff's personal injury lawyer's assets can be attached by the subrogation plan. I've read most of those cases. They go both ways. It's not guaranteed that you can be sued, because there are some cases saying that you can, and some cases saying that you cannot. My advice for you is it's too high of a risk. Don't just give the money to your client and say good luck. You better work something out. Anyway, that's that's what happened in Sereboff, is that there was the idea of a specific and identifiable fund. And then some very creative and ingenious lawyers decided that if it's about equity, then equitable defenses should apply. The Supreme Court had told us repeatedly in Sereboff and Knudsen that the only right in subrogation is an equitable right. And if it's equity, it's equity. And if it's equity, then all equitable defenses apply, including the common fund doctrine, the pro rata loss sharing doctrine, the made whole doctrine. Those should all apply. And in the case of CGI versus Rose, which again was Mr. Nelson was the one who thought of this, the United States, the Ninth Circuit agreed with that and held that equitable defenses apply to ERISA subrogation actions. Shortly after that, the United States came down with its decision in McCutcheon versus U.S. Airways, stating the opposite. And the Supreme Court, which had been talking so eloquently for years about equity, suddenly decided that ERISA subrogation is about contract. The contract says what the contract says. That was the holding. And the contract that they're talking about is the glossy contract that Home Depot hands to its employees and changes any time that some creative lawyer thinks about another way to tighten up the language. That's what they're talking about. So why is there an equitable trust? Why is it that you can be sued because of what's in your employer's handbook that your client has? You didn't sign this contract. You're not a party to it. The reason why you can be sued, well, it's because it's about equity, and it's an equitable trust. But wait a minute, it's a contract. So isn't it, we're talking about contractual liability? What the Supreme Court has done is it's mixed principles of contract with principles of equity in a way to apply them both in the way most favorable to the employers and most harshly against the injured employees who are trying to get something out of the personal injury settlement. That's about the only way that I can that's about the only way that I can describe it. Is this working now? That's the dog. Equity is the dog. If the dogs escape, there's no money. Knudsen was a good decision. It's ironic, saying that if you've distributed the money to your client, the dog's gone, and there is no subrogation. A few years later, Sereboff comes in and is bad, talking about how if they establish a trust, meaning if the money is in a specific and identifiable fund, then they can go after it. And then comes an Obama appointee, Justice Kagan, in a unanimous decision, U.S. Airways versus McCutcheon, which gutted all of the equitable remedies that could be associated with subrogation. So how do you deal with subrogation in a post-McCutcheon world? Well, one of the things that Lisa was talking about was you have some rights. You can strike back. One thing is you should be asking for there's a whole bunch of documents that you should be asking for, the Form 550s and other ones. And as soon as they assert that they are a fully self-funded ERISA plan, you should be asking for the Form 550s and other forms. They're all in my materials, by the way. You should also be asking for the original plan document or a copy thereof. What the ERISA subrogation collector will try to provide you upon request is not the plan. What will they try to provide you? Who knows?
Summary.
The SPD, the summary plan description. And there was another case that I'll talk about briefly where Justice Breyer said, if there's a difference between the language that's in the plan and the summary plan description, the plan itself will prevail. A plan is like a will. It's the original document. A summary plan description is something that a lawyer writes describing the plan. It may be accurate, and many times it is not. It's what the plan's lawyers wish the plan said, not what the plan actually says. I don't know why, but every time that I ask for the plan itself, they're always reluctant to give me the copy of the plan. They always give me the summary plan description, and they always say, this is the language. You should be happy with it. If you're going to get into a big fight with ERISA, in my opinion, it's malpractice if you rely upon the summary plan description itself and you do not demand the actual plan language. You've got to read it carefully. Many times these plans were written in a pre-McCutcheon or even a pre-Sereboff era, and they don't have the language in them that the plan's lawyers wish they had. Then maybe they don't have the made whole doctrine in there. Maybe they don't have something in there rejecting the common fund doctrine. If that's the case, if the plan language is silent on that issue, then the plan reverts to equitable principles, and all equitable principles apply, including your right to get attorney's fees or reduce it by a third for your fees, or if your client has not been made whole, you have the right to demand a full waiver. So one of the ways you can strike back is to demand a copy of the plan and don't be satisfied with the summary plan description. If you get into litigation with the ERISA plan, which is something that I would not recommend, having done it myself, and they refuse to give you the plan, eventually you can ask the court to fine them up to $110 per day for the refusal to give you the plan. Whether a federal district court judge will give you that money, it's discretionary, but it's something you can ask for. Here's another thing you can do. Examine the plan to find out whether it is a fully self-funded ERISA plan. The key language is fully self-funded. As Maria was alluding to earlier, ERISA is this very complicated statute that deals with employee retirement income, et cetera, of which subrogation is a very tiny part when you talk about the billions of dollars that are involved with ERISA plans. It's all we deal with, and so from our perspective, it's a really big deal, but in the larger scheme of ERISA, it's a very small part of it. And within the scheme of ERISA plans, there are fully self-funded ERISA plans, and there are insured ERISA plans. So the largest employers, the Home Depots, the Boeings, the Microsofts, the Pepsis, the Coca-Colas, they think it's cheaper for them to fully self-fund their employee insurance rather than paying premiums every month to an insurance company. But the smaller places would rather buy insurance, even though they may be buying insurance within ERISA. If that's the case, it's an insured plan. It may be ERISA, but it's still insured, and it's still governed by Washington state law. Washington state law that regulates insurance. All equitable remedies under state law will apply in that case. The made whole doctrine, your right to attorney's fees, and everything else. So when you examine these documents, make sure that if they tell you it's an ERISA plan, ask them whether it is fully self-funded, and then examine the documents themselves. These collection agencies will always tell you it's ERISA, they'll always tell you that it's fully self-funded, and time and time again, I've seen them misrepresent that. And what's that? I'm running out of time? All right, I'm sorry about that. Time and time again, I've seen them misrepresent their status. They're not fully self-funded, and there may not even be ERISA plans. So that's the second thing you do. The third way to strike back, this is something that I have done twice, is if you have a catastrophically injured client, and if there's not enough money to go around, if the amount of the bills are the same as the settlement or larger than the settlement, and the employer through the ERISA plan wants all the money, you can contact the employer and you can say, Maria has been a loyal, hardworking, dedicated employer, stacking lumber at Home Depot for years. She is your employee and she was catastrophically injured. While you have the right to get reimbursed for all of her medical bills, you can also waive that right. You can ask Maria who her supervisor is, and the supervisor can get you in touch with Human Resources, and you can go directly to Human Resources at your employer and ask them to waive the right to be reimbursed under ERISA. I've done this 3 times, and every time that I've asked, I've gotten either a complete waiver or a partial waiver. I would never do this in a case where you're talking about, $3,000 or $5,000 worth of medical bills. I've only done it on cases where I've represented people who are catastrophically injured, and all the money would go to the ERISA plan. Now, here's a couple things to bear in mind. One is that the Supreme Court has said that the whole purpose for subrogation is that the employer can take this money and then use it to give to employees as for the benefit of the entire employee class. So in theory, they would be taking that money and they would be reducing in premiums and all that kind of stuff. We know that they don't do that. It goes to corporate windfalls, it goes to CEO compensation, and it goes to everything but benefiting the employees. But at least in theory, the purpose for returning the money to the employer is to benefit the employees. So when you talk to a subrogation representative, such as Rawlings or one of these other companies, this is a representative on behalf of Aetna, which might be the third-party administrator for the employer. In other words, if Aetna pays with Aetna's money, then it's insurance. If Aetna pays with the employer's money, pays the medical bills with the employer's money, then it's acting as a third-party administrator, not an insurance company, on behalf of a fully self-funded ERISA plan. Am I going too fast? Everybody get it? All right. The point is that Rawlings may be collecting on behalf of Aetna, and Aetna is collecting on behalf of the employer. And if it's the employer's right to get the money, then it's the employer's right to waive the money. And if you can make ask them for a hardship exception, they can do that. As long as you're dealing with somebody at arm's length, such as the Aetna, the Rawlings or the Aetnas, you're never going to get anywhere. But you have the right to ask the employer directly to make the waiver. And if they'll do it, and they'll do it in writing, then you're scot-free and you can cut whatever deal you want. And I've done this a couple times. Again, I've only done this on catastrophically injured people, but it has worked.
If Aetna, for example, is the administrator for a plan, I don't understand the relationship. How is it that the employer has to get that when you do a waiver?
Okay.
Repeat the question.
Question is, if Aetna is a third-party administrator for a plan, how can the employer waive it? Right? Here's the difference. FMC versus Holiday was an early 1990s Supreme Court decision where it said that, Supreme Court said, if it's an insured plan, then it has to abide by state law that regulates insurance. If it's a fully self-funded plan, then it does not have to abide by state law. Rather, it is federally preempted. There is no federal law, there's no federal common law regulating insurance. Insurance is always regulated at the state level. In fact, insurance is one of the most heavily regulated industries in any state. But at the federal level, since the federal government defers to the states on insurance regulation, there's no federal common law on regulating insurance. So by seeking federal preemption, then by default, the only law that there is to apply is the contract, which is the glossy that Home Depot will hand to its employee. So the employer is able to write whatever it wants into the contract, change it at will, and then that becomes the law of the case in federal courts. So by getting full self-funding, the Home Depot, the big employer, is allowed to bypass state law, invoke federal law, which means the plan, and jump to the head of the line to get the money when the plaintiff settles his personal injury case. So that's why I said you're not only fighting to get the money, you're fighting to keep it, and the ERISA plans want to jump to the head of the line by relying upon their contract. So when Home Depot, Boeing, Pepsi, Microsoft, whatever, when they hire Regents or Aetna or anything else, Aetna's not acting as an insurance company. They're not paying, Aetna does not pay the medical bills with Aetna's money. Aetna is acting as a third-party administrator. It looks like an insurance company. It acts like an insurance company. It walks like an insurance company. It quacks like an insurance company, but it's a third-party administrator. The difference is, at least in theory, that it's paying the claims with the employer's money, not with Aetna's money. And the employer, rather than paying premiums every month to Aetna, and then Aetna pays it with its own money, the employer just pays Aetna a lower amount simply to administer the claims. So Aetna in that context becomes a third-party administrator rather than an insurer.
What's your view on stop-loss insurance that reimburses the plan after a certain level of
So the question was about stop-loss insurance. So stop-loss insurance, think of it as a deductible. So your client is a member of the union. He's a firefighter, and he was badly injured. And the union's plan is self-funded up to $250,000. After $250,000, stop-loss insurance applies and will pay for any medical bills that exceed that amount. Okay? So your client's medical bills are $750,000. The first $250,000 were paid by the third-party administrator on behalf of the plan, and the next $500,000 were paid by insurance. Right?
So you don't think that the plan, many of the plans are set up so that it's a reimbursement to the employer. The employer pays the medical bill when you get reimbursed. But you don't think that's
I think it does. So, I'm sorry. Repeat the question so I can repeat it back to the audience.
sorry.
This is actually a really good question.
Yeah. And just a reminder, we have 80 people participating by webinar, so we have to be sure that they hear the question as well.
Okay.
Thanks.
The follow-up question was that many of these stop-loss insurance plans appear to be set up to reimburse the employer after the employer initially pays for the medical bills, and whether that distinction is important.
Well, I've always taken the position, and I think that you should take the position, that if every dollar after the stop loss is insurance, and they're governed by Washington law regarding insurance, and if your client was not made whole, then the insurance money, the insurance company has to eat it.
There's maybe case law.
Yep, I know. This is,
The site Mike Maxwell on that.
yeah, excite me. There is an awful lot of uncertainty. There's an awful lot of uncertainty in ERISA litigation right now. Every time the Supreme Court makes a pronouncement and tries to tidy everything up, everything changes. And one thing you can do is you can put the money in your own trust account and tell them you're not paying until they reach an agreement with you. In the CGI versus Rose case, the one that was decided in the Ninth Circuit, Mr. Nelson, referring to him again, took the money in his trust account and said to the ERISA plan, come and get it. The ERISA plan sued Mr. Nelson's client, but also sued Mr. Nelson's law firm. And the Ninth Circuit said, since he put the money in his trust account, he cannot personally be sued. And that, to my knowledge, is the last word that we got from the Ninth Circuit. So you can do that and put it in your trust account, and so.
You had asserted that when there's insurance, state laws regulating insurance applies, and that made whole and common fund applies. I've seen insurance companies argue that even when it's a fully insured plan, Thuringer, Mahler, and the rest are not state laws regulating insurance. They don't qualify for saving under ERISA. What's been your experience with that?
They do that all the time. So this is an example of insurance companies trying to get more benefits than the ones to which they're allowed. They're not allowed to do that. FMC versus Holiday is very clear. If it's an insured plan, state law that regulates insurance applies. Josh?
This is not so much a question, Mike, as much as a comment about something that we have been trying to do when negotiating on the ERISA plans. So when you get the money, so normally when you deal with these plans, right, is at the end of the litigation after you've already received the money. When you have the money, if they have a plan that says they get every dollar, they've kind of got you, right? They've got you stuck. You've got the plan. You're stuck paying for it. So what we have been trying to do is actually get this up front, get the plan up front, and start talking with the subrogation folks right at the beginning and say, look, we can pursue this or we can not pursue this, and you have the right to go ahead and pursue the claim. That's what the subrogation says, that they have the right to pursue the claim on behalf of the plaintiff. But what we have been saying is, let's negotiate from the beginning. So rather than saying, wait till the end when they've got the money and they've got you stuck and say, we get all of it, start from the beginning, say, we want waiver, ask for waiver. They most of the time will not grant it. But then we've started bracketing and saying, all right, well, if we get up to X number of dollars, we waive. If we get from X to Z dollars, we ask for this percentage reduction. And you negotiate up front before you have the money on the table and before you're stuck. And we've been trying to do this up front. And we've actually had some success at having the ERISA providers and the plan administrators, the Rawlings of the world, say okay up front and negotiate that, because they'd rather get something rather than nothing and have you not pursue the litigation on behalf of the client.
That's a really good idea. I'm glad to know that you've been successful with that. I proposed that a couple times myself, and I've never been successful. So maybe your powers of persuasion are much better than mine. But if you can do that, negotiate some sort of a pre-contractual deal, that's a good idea. I'll tell you one thing, Josh, when you talked about once you've taken the money and once you've settled, the horse is out of the barn, your opportunity to exert leverage over these guys is gone. It's absolutely right. So what I've done several times is I have not settled. I've gotten the best settlement offer, I've gotten the policy limits or whatever, and then I've called the ERISA plan and I said, we aren't going to settle unless you come to the table and negotiate. One time I had to settle because we had a bunch of issues going on, and so we settled conditional upon a satisfactory resolution of the ERISA lien, and nobody was getting any money until the ERISA lien finally capitulated, and it took a long time. But that's one thing you can do, is if you settle and your money's in your trust account, your leverage is, you've given away your leverage. So try to, if you've got a big, hairy, unpleasant ERISA issue, one way to deal with them is to not settle or settle conditional upon a satisfactory resolution of the ERISA lien.
We're going to take, in the interest of time, we're going to take one more question for Mike. There will be Q&A at the end of the day for further questions. So one more question and then we need to move on.
If you're holding the money in your trust account and you've notified the ERISA plan of the settlement, what statute of limitations applies for their suing to get the money?
This is Robert, and Robert, you are from Arizona, correct? Yeah. So Arizona has a 1-year statute, and recently an ERISA action was dismissed. The federal government, or excuse me, federal courts look to state law regarding statutes of limitation. There is no statute of limitations set forth in the ERISA statute. So the federal courts have said, well, we look to the most analogous state court law. And so I think in Washington State, the most analogous state court law would probably be our 6-year statute of limitations on a written contract. In Arizona, there was I forget which one it was, but there was a 1-year statute of limitations that the federal court applied to an ERISA plan and found that the ERISA plan was time barred by the statute of limitations. I'm really glad you asked that, because one thing that I'm suggesting for next year's legislative push is that WSAJ should be pushing for a 1-year statute of limitations for subrogation actions. And I think that if we pass that, that would be the most analogous law, and the federal courts would be bound to apply it.
Okay. Thank you, Mike.
Okay.